time. Thank you.
Thank you. Mr. Caldwell, good morning.
My name is Ryan Caldwell. I represent the appellee, Nebraska Freeman. I just wanted to start by first addressing Mr. Groskopf's issues of appeal with regard to the earning capacity that the court had established. I think it's clear, based upon the circumstances, that the court was correct in awarding the $15.23 an hour for an earning capacity based upon the actions of Mr. Groskopf. At the previous modification hearing, he was going to school. That's why he requested a reduction in his child support. He had indicated at that time that after concluding his education, he was going to be earning somewhere around $30 to $40 an hour. After graduation, at some point he decided he was going to do a career change and decided to try the law enforcement. But instead of trying to find a paid job, he was doing voluntary work instead of getting something that would be able to provide for his child. After Ms. Freeman's second modification complaint was filed, Mr. Groskopf did receive the employment at Butler Machinery. He was earning $15.23 an hour, and at the time of trial, he had indicated that if he were not to go into school, he would have continued to earn that amount of money. Additionally,
counsel, does the record, I want to be clear on the timing, does the record show that at the time that application was filed, he already had the job at $15.23 an hour?
He did not, Your Honor. The complaint, I believe, was filed in February of 2012. I believe he accepted that position in June of 2012. And a part of...
For purposes of determining the facts, is it the situation that exists at the time the modification is filed, or is it the situation at the time the court enters the order with regard to the filed by the wife?
I believe I had a previous case with the Court of Appeals, and they had indicated that we take a look at the situation at the time of trial. And even when Ms. Freeman filed her complaint, she was under the assumption that Mr. Groskopf had earned a job at making $30 to $40 an hour like he had indicated he would after concluding his education. But I also wanted to reflect that with regard to this educational opportunity with Butler Machinery, he was still earning, Mr. Groskopf was still earning $15.23 an hour for certain periods of the year. I believe the way that the schooling system worked was he worked for 2 months and he went to school for a month or two. So he was still earning income at that time. The testimony was also that his father was paying for all of his expenses, and so including child support and the school tuition, so he should have enough money to be able to pay his own way for child support purposes, and this kind of jumps to my cross-appeal argument.
Well, is the fact that the father pays support for the son, is that a factor that the court considers in determining whether to modify the decree or not? Does that fact weigh in favor of the spouse, that the grandparents are paying for the support?
Well, I believe it's an indication that that Mr. Groskopf is doing something in bad faith with regard to his employment opportunities.
Your basic position at the time you filed the modification was he had completed or was capable of earning at least $30 an hour.
That's correct.
Okay.
Going to the issue of retroactivity of the child support, I believe this court had indicated that in the absence of bad faith, it would be an abuse of discretion to apply retroactive support if there is evidence showing that the parent doesn't have the ability to pay the lump sum amount that would accrue the arrearage and current obligations. I think the district court had estimated that there was bad faith on the part of Mr. Groskopf because of his employment situation prior to the trial. Additionally, the evidence was that Mr. Groskopf's father was paying all of its expenses, and I had mentioned earlier that Mr. Groskopf was still earning some kind of form of income while he's going to school with Butler Machinery, and so he would have the ability to pay the lump sum arrearage, and I think I would estimate it would be around $2,000.
Counsel, first I want to ask about the question. What we previously said is, in the absence of bad faith, it would be an abuse of discretion to require retroactive support. But we've never said, in the presence of bad faith, it would be an abuse of discretion not to order retroactive support, correct?
That would be correct.
So that converse may be true or it may not be true. We haven't spoken to that issue yet.
That is correct.
In this instance, is there evidence from which the trial court could have decided he was in bad faith in not paying something, but not in so far in bad faith that he should be made to pay retroactively? In other words, does this fall within that range of discretion that the trial court ought to have? And if not, why not?
Well, yeah, I do believe that the court has the discretion. However, I believe in this situation, the district court had indicated that despite the bad faith, they were going to give Mr. Groskopf kind of an opportunity to prove himself that he will take care of his child. And while that's great, we do believe that the situation is that he should be ordered to pay the retroactive support just based upon his bad faith, based upon his ability to pay, based upon his father's taking care of all of his expenses so that he does have the ability to pay. I think all of those issues lumped together.
Does the father have a duty to pay his child support?
Absolutely not, but the fact that he does is beneficial to Mr. Groskopf's ability to provide support to his child, which he hasn't been doing.
Well, you asked for child care expenses, and the court did not rule on that. Is that correct?
That's correct.
So, where does that leave it? Is that a denial or?
I believe the court said, I think it was the final paragraph of the order, any other issues not determined at the time are deemed denied. Our argument is that Mr. Groskopf should be required to pay his proportion of child care expenses. Mrs. Freeman, or excuse me, Ms. Freeman.
Going forward, not retroactively.
I can't say I know the case law with regard to whether
You're asking for child care expenses going forward.
Correct.
Correct.
Ms.
Well,
Freeman.
how do you raise that? Did you cross appeal?
Yes, we cross-appealed, Your Honor. And in that, we were just arguing that because previously, Mr. Groskopf, in the previous modification order, because the court had indicated his earning capacity at minimum wage, he fell under the poverty limitations that the child support guidelines set forth that prohibit the court from ordering child care expenses. But now that Mr. Groskopf's earning capacity has increased and he's now no longer in the poverty level, the court should have, we believe, provided and rewarded.
Did you put any evidence on this to child care expenses?
Yes, significantly. Ms. Freeman indicated that she currently works full-time, goes to school full-time, trying to earn a master's degree. She takes seasonal work in order to provide for her family, and in order to do all of that, she has child care expenses.
So what were you asking for?
I believe we were just asking for the proportion based upon the child support guidelines, which I think was 47% of
And what would that be in dollars?
Your Honor, I have no idea. That basically concludes my argument, unless there's any further questions. Thank you very much.
Thank you very much. Do we have time for rebuttal? There is no time for rebuttal. That takes